This might seem like a very lawyerly and unnecessary video, but there are some important concepts you need to know about remedies if you are ever faced with a lawsuit. To a degree, this video is about talking like a lawyer, but mainly it's about legal concepts such as when somebody has suffered a loss and how the loss can be fixed. Fixed is, of course, a non-lawyer word. In simple words, remedy is what the winner gets at the end of a lawsuit. More precisely, a remedy is the method of court enforcement, or is the award resulting from a successful lawsuit. A remedy is the means by which a court enforces a right, awards money, or imposes a penalty after a legal battle. The laws of remedies set limits or standards for awarding money and other relief to prevailing litigants. If there is no law saying a remedy is available, then you cannot expect a judge to give it. Over the years, people have come up with novel claims, and a lot of times they get shot down. For example, taxpayers have tried to sue the government claiming tax money is being misspent, but the courts have taken the position that taxpayers have no such remedy, at least not against their own government. But as has been explained in other videos, the law changes, and sometimes judges give remedies that have never been given before, but that is extremely rare. Judges, especially lower court judges, do not change the law as often as people hope. To get the law changed, you must bet against history and take the case all the way to the highest possible court. Some people will use the words relief or damages or compensation instead of saying remedy, but the word remedy is the word lawyers understand best for talking about all the different kinds of things that could be accomplished at the end of a lawsuit. In fact, the best law schools have classes called Remedies, in which law students learn about this topic, which can be more complicated than most people imagine. Damages is another special word for lawyers. It refers to any legal loss that somebody has suffered, whether it be property damage, or physical illness, or injury, or death, or damaged reputation, or loss of income, or loss of enjoyment of life, and many more things. But damages can also refer to money compensation. You will hear lawyers talk about the measurement of damages, or the measure of damages, and recovery for damages, which both mean money. But it is theoretically possible to remedy damages without money. For example, if person A sues person B because person B took a painting belonging to person A, the judge could award person A money. Or the judge could simply order person B to give back the painting. A loss is usually necessary for a successful lawsuit, but not always. More on that in a moment. And when I say a loss is necessary, you've got to go to court to get something fixed. Unless somebody has lost their health, lost their property, lost something that can be measured, or lost a legal right, then a judge will ask, what is the point in a lawsuit? For example, if two people in the year 2020 argue about the World Series of 1915, they have an honest dispute that could be resolved by a judge. But what does that accomplish? When a dispute has already been settled, or when the parties to a dispute have suffered no loss, that is usually called a moot case, and courts do not want to waste their time on moot cases. Sometimes lawsuits are called unripe, which means somebody might suffer a loss, but nobody has suffered yet, and they might never suffer. For example, if two people are confused about a contract, but so far they both continue to follow the contract, then neither has been hurt and the dispute could be called unripe. This is actually a tricky example because a court could make a declaratory decision on how to interpret a contract if there is a dispute between the parties to the contract. See below for more on that. There are three kinds of remedies in theory. 1. Money. 2. Equitable remedies. 3. Declaratory judgments. Let's start with declaratory judgments because they are the most rare. In those situations, a court will make an official ruling to settle a dispute, but will not award any side money. except maybe some attorney's fees, and will not order any side to do anything in particular. Declaratory judgments are rare because they are supposed to be available whenever there is a dispute, but nobody has been hurt or damaged, usually because the dispute needs to be settled before somebody suffers a loss or because loss is imminent. Really, the situation falls in that rare kind of territory where nobody's been hurt yet, but everyone expects it's going to happen pretty soon. In Texas, declaratory judgments are made possible by Chapter 37 of the Texas Civil Practice and Remedies Code, which gives Texas courts the power to declare rights, status, and other legal relations whether or not further relief is or could be claimed. The Texas law applies when there is a dispute about legal rights, legal status, and other legal relations such as ownership of land, the meaning of zoning ordinances, and the results of an election. The Texas law does not apply to disputes that are not legal, such as the best flavor of ice cream. Regarding equitable remedies, they include court orders to do or not do something. Like the example in which person B stole person A's painting, the order to return the painting is an equitable remedy. Over the years, equitable remedies have made news, such as when school districts were ordered to integrate schools, when Texas prisons were ordered to install air conditioning, when local governments were ordered to remove 10 Commandments, or remove nativity scenes during Christmas. But usually equitable remedies are not so famous, such as ordering a neighbor to tear down a fence, ordering a tenant to vacate an apartment, ordering a bank to open a safety deposit box, or ordering a business to shut down. Generally, equitable relief is allowed only when money damages are insufficient to correct the loss. In other words, when money fixes the dispute, then the judge will simply order that money be paid. This brings us to an important concept in the law: making the victim whole again. The law tries to put victims back to the way they were before. For example, if somebody's property is destroyed, the law tries to award the victim whatever money is necessary so they can buy a replacement. Another example: if a home builder breaks a contract or builds a defective home, the law tries to award the victim enough money to build the home or fix the home the way it was supposed to be done in the first place. This is a fine idea in theory, but it can be very complicated in cases. For example, how much money should a person get when their spouse is killed? Some people think there is not enough money in the world to compensate a bereaved wife or husband, but the law approaches this question differently. This example of death is something lawyers, economists, judges, and juries struggle with every week across the country. And what about a situation in which a person did not die, but they suffered burns to 95% of their body? There are no easy answers many times. We will not spend a lot of time on the measure of damages, and before spending any more time on it, let's talk about the one last example of equitable relief. Let's say Bill Byer and Sam Seller made a contract for a house. Bill Byer agreed in writing to pay $200,000 for the house, but when it came time for Sam Seller to sign the deed, he refused. Sam Seller said, "I simply changed my mind, and I'm returning all of your money." Can Bill Byer get a court order for the house? Probably. With a few exceptions, every house is different. Not like a cheap TV. If Sam Seller destroyed somebody's TV, he could simply pay for it. But most houses are not so easily replaceable. Each one has a unique history and location. Sam Seller could claim Bill Byer is the same as he was before. Specifically, Bill Byer has all of his money still. But Sam Seller is ignoring two things. First, before Sam Seller changed his mind, Bill Byer had a legal right to that specific house if he paid all the money. It is called a contingent right because the right to possess the house is contingent on paying the money. But it's still a legal right. Second, it might be impossible for Bill Byer to find a house like Sam Seller's. There are some houses that look all the same and are in virtually the same location, but most houses are unique. Finally, let's talk about money damages. The law is surprisingly specific about what a victim can recover. Take a simple example of an airplane damaged by a clumsy mechanic. The law is that the victim can recover either 1, the cost of repair plus lost use, or 2, the fair market value of the airplane immediately before the damage. Cost of repair is defined as the minimum amount of money required to restore the airplane to its condition immediately before the damage. A judge is not going to make the clumsy mechanic pay the highest repair bill. But also the judge and jury will want the mechanic to pay for all that needs to be done to restore the airplane. So the mechanic should not expect to pay for a shoddy and cheap repair job. Lost use is usually measured as the value of transportation while the airplane owner does not have the airplane. That is mostly while the airplane is being repaired. And most people go by the cost of renting an airplane, similar to the airplane that was damaged. But the victim is not simply given a choice. The clumsy mechanic need not pay for the whole airplane if repair won't cost too much. And the mechanic need not pay for a repair if the value of the airplane is cheaper. This is where the concept of totaled comes in. Let's say the cost of repairing the airplane is indisputably $55,000, but the airplane is only worth $50,000. Then in that case the airplane is said to be totaled. Fair market value is defined as the price that a willing buyer would pay a willing seller when neither is compelled to buy or sell. Fair market value as a concept does not work so well with weird items such as historic artifacts or classic paintings, or items with niche markets such as baseball cards or other collectibles. Fair market value does not account for sentimental value. A used birthday card might not be worth 1 penny on eBay, but it might be worth a lot of money to the grandmother who got the card from her only grandchild. Fair market value can vary from location to location as well. Potted mesquite trees might sell for $30 each in downtown Houston, but they would have a negative value in Tom Green County where people pay money to kill them. A person who pays fair market value for an item often gets to keep the item. The paying person has essentially bought it. If a victim wants to be compensated for a totaled or destroyed item but does not want to lose it, then they can usually deduct the scrap value from the compensation. For example, if an airplane is worth $50,000 and needs $55,000 in repairs, then it is by definition totaled. But let's say the scrap value of the plane is $1,000. Then the victim could agree to accept $49,000 and keep the scrap. In theory, the victim comes out the same. Before the airplane was destroyed, the victim had something worth $50,000. And after the settlement, the victim had something worth $1,000 plus $49,000 cash, for a total of $50,000, just like before. Lost use will not be awarded to a victim who received fair market value because, according to the theory, fair market value includes the value of using the item. The theory is that people buy something in order to use it. So, when they get paid for it, they also get paid for not using it. Finally, let me say this about insurance. This might or might not apply to insurance claims. It depends on what kind of insurance is involved and what the insurance policy says. All the remedy rules we have discussed apply when there is a victim, and there is a person in the wrong, and there is no contract that says something different. If the basis of liability is only an insurance policy, then the terms of the policy will dictate the result because insurance is just a contract and the contract will be enforced. Take, for example, lost use. You might have paid for an insurance policy that will pay for damage to your helicopter, but the insurance company will not pay for a rental helicopter while your damaged helicopter is being repaired unless the insurance policy says so. That's all. I hope you've learned something. If you have any questions, feel free to ask. Thank you.